right, we have Arise analyst Frank Tietie, who is a lawyer, joining us, as always, tonight on Newsnight. Good to see you.
My pleasure.
Now, let's begin from this Awka, Anambra State, where the Federal High Court judge, goes back on his own judgment. Is it a sign that he himself did not do due diligence? Is this not a self-indictment?
Not at all. The interesting
what exactly is playing out here?
Not at all. The public must understand that law has rules, and court operates by what we call rules of court. And in this case, we've seen somebody who's trying to be clever by half, trying to mislead the court. And if you go by the specific rules of court, whether state high court or in this case federal high court, particularly Order 10, Rule 14, states that any judgment that is obtained either by fraud or by non-service, or where the court did not have jurisdiction to hear the matter in the first place, that same court would, on application by any party that is affected, that same court has the powers to now reverse itself by, by nullifying the judgment. And that's according to law. And then you need to look at the facts. And if you look at the reportage, and I've had the privilege of reading the ruling, it was clear that the Inspector General of Police was not even served was not served the originating process. That means that the documents for which that initiated the matter, the originating summons, was not served on the Inspector General of Police. And if you look at the fundamental law of the land, particularly Section 36, which establishes the right of fair hearing, that is, he must have the opportunity to defend himself. He didn't have it. And again, you also need to look at the issue of fraud, because whenever you file a matter before the Federal High Court, you must depose to an affidavit stating that those matters have not come up before any of the branches, any of the Federal High Courts across the country, and that Federal High Court is exercising original jurisdiction, whereas in the Federal High Court matter in Abuja, where Justice Omotosho decided the same issues in the case of Michael Idoko and the Inspector General of Police, the same issues. The court held that the individual did not have the local standard to challenge the status of the appointment of the Inspector General of Police. Very fine issues were raised, and the counter issues were also raised, whether or not the appointment of the Inspector General of Police is a political appointment, and that the new amendment that states a definite number of years or 4 years, very brilliant issues were raised, and the court laid it to rest that the man didn't have a local standard. To now play fast one on the Federal High Court in Oka to make it think as if it had jurisdiction, because it amounted to abuse of court process. So as we speak, there is a substantive Inspector General of Police, and that the court was misled. There were issues of fraud and non-service, and the court had to set aside its own judgment. And that is perfectly in order according to the rules of court.
Frank, here is the grouse. At what point did the judge realize that the IGP wasn't served the originating summon?
It is also important that public understand something. You see, the court is a repository of all the laws of the country, not all the facts. There is a judge sitting in Oka, and he restricts himself to the facts that are given to him based on affidavit. Affidavits are sacrosanct, and there is an interesting part of the affidavit evidence. Now, until it was brought to his knowledge that, look, a non-service was not effected in this case, and then there was fraud, and then there was an affidavit by the bailiff of the court before the court that it did not and it could not serve the IGP. So the court at that point, realizing that couldn't have done otherwise, but to set aside its own judgment.
Any punitive measures for those who allegedly may have, fraudulently not done the proper thing before bringing this particular case before the judge? And very quickly, let's also talk about, this civil society contact group who is saying, look, for you to appoint the next IGP, Inspector General of Police, there must be he must have a lot of time.
I think we shouldn't be preemptive here. Right. We have a substantive Inspector General of Police.
But is it a valid point they are making?
The point is this. The point, when you look at the import of Section 7, that restricts the time or the tenure of an age to 4 years.
Right.
The question is it is not whether the IG has 4 years. It is whether he has been appointed by the president while the IG is still while he is still a policeman. And whenever he is appointed, he must therefore stay for 4 years. So the question,
whether his time in the
that
force
does not come up, because there is no law that says the IG should step down after he has been appointed when he no longer has up to 4 years in the office. Whereas there is a clear law that he must have he should serve for 4 years. And then when you look at the fundamental law, which is the Constitution, that says that the president can appoint an Inspector General of Police. And by that appointment, that is political. It has gone beyond the realm of public service rules. But that now becomes, civil service rules and public service rules, and then that becomes political. The presumption is that he should stay for 4 years. So we don't know what the president has in mind, whether he's going to keep Usman Alkali Baba for 4 years, but as long as he's a substantive Inspector General of Police, he will serve his time. And if the president adopts him as his own Inspector General of Police, we might see him serving another 4 years. But what the law presumes is that any policeman that has been appointed, 7 policemen that has been appointed and Inspector General of Police, he must serve for 4 years.
So that's what the Nigeria Police Act 2020 says.
Yes, Section 7 specifically. And even the interesting part of it is that even if he has passed the retirement age of 60, and I must have even served beyond 5 years, so long as when he was he was a 7 policeman, he was appointed by the president, he is bound to serve for 4 years.
I know that's what Section 7 subsection 6 says. I know. But then yet again, it also says the same act, in fact the same section says the police council shall regulate its own law. Now in this case, to avoid any fracas and misunderstandings between agencies and the police and
sending wrong signals.
To avoid sending wrong signals, is there no way the police council can then make amendments to their own rules, such that even though he hasn't served 4 years, if he's clocked the retirement age, can he then bow out?
No, let's understand something. The Inspector General of Police is an appointee of the president pursuant to the Constitution, which is above the law.
Yes, but hang on there, Frank. I also understand that the police council should make a recommendation to the president
for the purpose of appointment.
Yes,
and such recommendations most times they're not usually one person. But again, nobody and no law takes away the prerogative of the president to make an appointment. So when the president has made an appointment of a 7 police officer as the Inspector General of Police, he is above the level of the Police Service Commission. They cannot make rules that will even affect him. He is directly accountable to the president. But where the Police Service Commission can deal with the lower police officers like the DIGs and the Assistant Inspector General of Police, but the Inspector General of Police is in a different class. He holds a special appointment directly responsible.
So what
to
you're
the
saying is that
the
police council cannot hold the IGP accountable.
Well, there are several other rules that hold and laws that hold the Inspector General of Police accountable. But when you're dealing with the issue of appointment, it is strictly with the prerogative of the president, and it is also guided by the Police Act. In this case, once the president appoints a 7 police officer as the Inspector General of Police, he's bound to serve for 4 years, and when he is 7, he holds his accountability directly to the president of the Federal Republic of Nigeria.
Interesting. That's interesting.
Very, very interesting indeed. Frank Tietie is a lawyer and a RISE News analyst. Thank you very much.